Sorry not to be bang on time, Mr. Moretto. My fault. Yes.
My lord, I have 4 areas to deal with. 1, the principle of how to deal with the justification argument. 2, specifically the NHS. We haven't touched on that yet. 3, I need to touch on the status issue because no one's mentioned that yet. I'll be very brief. And 4, I'll deal with remedy again very briefly at the end. Dealing firstly with the principle and the approach to justification. In summary, our position is that the Supreme Court in SC, a 7-court Supreme Court, carried out a detailed analysis of the approach to properly adopting an Article 14 case. And that is the approach that very much ought to be applied in this case. We say the upshot is that a wide ambit must be given to decisions of Parliament. Whether that is termed as manifestly without reasonable foundation or something very close is not really a significant issue. It is a very wide ambit that must be given to the decision of Parliament. That is for 3 primary reasons. Firstly, the matter here at stake, the legislation, the primary legislation, has clearly been reviewed and reviewed recently by Parliament, the specific matter that is under issue here. Secondly, this is not anywhere close to a suspect head of discrimination. If one is applying the Lord Walker concentric circles, we are, in this case, at the very periphery of the status solar system. And 3, we are dealing here with social policy. It's true we're not dealing with the allocation of public money, but instead we are dealing with social policy and the rights of individuals, both to make claims but also have claims made against them and their property and their own individual rights. And in those circumstances, it is ultimately for Parliament to balance those competing rights, and Parliament's decisions ought to be respected unless those decisions are clearly without reasonable foundation or in essence irrational. That high level of the high measure of test has to be overcome by the claimants in this case. I'll turn to a number of authorities and I'll come to SC in due course. First, I should turn to Gillen because the claimants say, well, you are bound by the approach in Gillen, they say, which is not SC. And Gillen is at tab 34, which is, I think, at the end of Authorities Bundle 1. The Supreme Court, Baroness Hill, deals with the question of justification from paragraph 33 onwards, and it refers to a lot of this, but not all of it. So at paragraph 33, which is page 1055, the answer to question 4, now question 4 is whether the difference is without reasonable justification. Baroness Hill says, in my view, clearly yes. They set out the respondent's argument that this is an area of social policy in which decisions of the democratically elected legislature must be respected unless manifestly without reasonable foundation. And the status in question is not suspect ground. She then goes on to set out, and you've been referred to paragraph 34 onwards, there are several problems with this argument. The short point, however, is if one turns to paragraph 37, the Supreme Court does not make any finding decision as to what is the appropriate approach to apply, the appropriate level of review, because in short, no justification has been put forward at all.
Okay.
So there is no decision there which is binding on this court. Now, in terms of paragraph 34, there is a very brief analysis. Baroness Hill talks about manifestly without reasonable foundation test being applied in cases relating to the benefit system. And then goes on, this is the top of page 1056. She says, it's also in that context, the test has been articulated by the European Court in SEC, and then says this case is not in that category, but rather in the category of social or employment policy, where the courts have not always adopted that test. See G. Now I'll come to G, but obviously the first point to note is she says they're very clearly not always adopted that test, which shows they have adopted that test in some cases. Now, I'll come to G. Before coming to G, I'll deal very briefly with paragraph 35, which is the question about the consideration that has been shown by Parliament. Well, 2 points. Firstly, this case is very different because there is clear determination by Parliament in respect of the issue before this court. But secondly, and in any event, that one paragraph of discussion has very much been overtaken by the very detailed discussion by the Supreme Court in SC. Again, that's 7 court Supreme Court. 36 just sets out the point that no legitimate aim has been put forward. Now, dealing with G then, that is at tab 19. This is a case involving the Northern Ireland order, which prevented those who were not married adopting. It was a blanket ban on all those who were not married adopting. What the court actually held in that case was that the line drawn in that case was one that was irrational. And we can see that by reference to Lord Hoffman's decision at paragraph 16, I think. 16, which is at page 438. Paragraph 16, the question, therefore, is whether in this case there is a rational basis for having any bright line rule. In my opinion, such a rule is quite irrational. So, in fact, the court has asked itself the question, the approach is there a rational basis? And answered, there is no rational basis, it is quite irrational. And just to confirm, that was the ratio. If one looks at paragraph 18, Lord Hoffman returns to this. Essentially, the issue was unmarried couples could not adopt, and there was a blanket rule. And in addition, single parents could adopt. So what the Supreme Court essentially said was that this rule is irrational, firstly because there is a blanket rule, and secondly because it doesn't make any sense that unmarried parents can't adopt, whereas single parents can.
Tantamount to saying no logical justification.
Absolutely. And a paragraph.
So you didn't need to say what the test was.
Aren't we spending quite a lot of time on this point, on this case? I mean, what?
No, I'm simply saying the one authority that Lady Hale referred to as saying a different approach has been taken is actually one in which the majority of the Supreme Court was actually determining the cases on the basis that the order was irrational.
Okay, have the point, yeah.
And I Lord Hope and Mance agreed, just for reference, paragraph 56 and 125. Now, turning then to SC, which is at tab 48. Now, I'll wait till you're there. it is a case which involves benefits, there's no doubt about that, and there are some paragraphs that specifically refer to benefits. But more generally, it makes very clear, the decision is very clearly not limited to benefit cases.
Yeah.
And so one can see, for example, when the question is asked at paragraph 2, subparagraph 7 at page 1539. This is the beginning of the decision of the Supreme Court. Roman numerals 2, 7 Roman numerals 2. The court asks itself the question of whether the approach to proportionality under Article 14 to the effect the court will respect the policy choice of executive or legislature in relation
Sorry, where are you reading from?
Sorry, 7 Roman numerals 2, page 1539.
Thank you.
And the question they ask themselves is, and they're answering, is whether the court should respect the policy choice of the executive or legislature in relation to measures of economic or social strategy, unless manifestly without reasonable foundation. So that's the question they're asking themselves. When the, and again, one can see, if one turns to 1549 at paragraph 37, so that sets out the test they're applying, the Article 14 test. Just for reference, the question is whether 37.3 and 4 is the question is whether there's no objective and reasonable justification, and whether contracting state, well, they sets out that the Supreme Court say the contracting state sets out, enjoys a margin of appreciation. It will vary according to circumstances, subject matter, and the background. So again, that's a generality of the case. Now, when the Supreme Court look in detail at the question of justification and they look at the question of status, obviously, large number of the cases are benefit cases, but many are not. So, for example, if one looks at paragraph 101 at page 1564, so 1565, sorry. Paragraph 101 deals with Abdulaziz, which is an immigration case. Paragraph 102 deals with a case of Markin, which is a case relating to parental leave.
If all you're doing is making the point that this isn't only about benefits, I think that's, I don't think that's in dispute. And quite clear, Lord Reeves set out here to have a general overview of the application of Article 14 in cases brought against the government out of legislation.
I won't go through that in any more detail, but then I mean, the fundamental decision, the fundamental paragraphs, obviously, that we rely on, in particular, paragraph 144, which talks about the need for respect of separation of powers between the judiciary and elected branches. Again, talks about accord appropriate respect to choices made in the field of social and economic policy. Obviously, there will come a point when the justification for policy is so weak, it's been drawn in an arbitrary position, even with that broad margin appreciation, it's unjustifiable. We say that's not that case here. Paragraph 146 says that this approach, i.e. the broad margin of appreciation, is nothing new or alien, and it accords high level of respect to the judgment of public authorities in the field of social policy, and talks about the but balances the need for close scrutiny where differences of treatment are based on suspect grounds. Again, that's not this case. Paragraph 146 at the bottom of that, administrative law test of unreasonableness is generally applied in contexts such as economic and social policy with considerable care of caution. The same is true of the convention test of proportionality because it reconciles a rule of law with the separation of powers. And as I refer to all these parts in my submissions. Paragraph 157 is the court's conclusions, and a particular conclusion is at paragraph 161.
And 148 is what the starting point of the test, is it? It's a nuanced judgment which is required.
Yeah.
Yeah.
Well, yeah. So 151, if one looks at that, so the manifestly without reasonable foundation test, as used in Strasbourg judgment, does not express the test in the sense of a requirement whose satisfaction or non-satisfaction will itself necessarily be determined to the outcome. The phrase indicates a width of the margin of appreciation and hence intensity of review. As I've explained, however, a number of other factors may also be relevant in the circumstance of particular cases, some of which may call for a stricter standard of review. So the nuanced approach, well, the conclusions begin at 157, and really 159 is the part there about the nuanced approach. It's therefore important to avoid a mechanical approach to these matters, based simply on the categorisation of ground of difference. More flexible approach will give appropriate respect to the assessment of democratically accountable institutions, but will take appropriate account of such other factors that may be relevant. As was recognised in Gaidan and RJM, the court should generally be very slow to intervene in areas of social and economic policy, such as housing and social security, but as a general rule, differential treatment on grounds of sex or race nevertheless requires cogent justification. And paragraph 161 is then sort of the key point, and that's the point that says, you know, rather than trying to perform the arid exercise of working out exactly what the ambit of the manifestly without reasonable foundation test is, it's more fruitful to focus on whether there is a wide margin of appreciation.
Yeah, this is all very familiar.
So, as I say, now, just in respect of the, my lord, you mentioned, you asked whether I sort of cling to the old formulation of manifestly without reasonable foundation.
What did I ask?
You asked yesterday whether I would cling to the old formulation of manifestly
I'd
without
forgotten
reasonable
that.
foundation.
Respecting the answer was no. Maybe I'm wrong.
Our position is, in essence, it's a very wide ambit, which is in essence the same thing. It's a question of rationality. And the reason that is shown, for example, in A and B, which, although it appeared much earlier in the bundle, was actually handed down immediately after SC, and it's the first Supreme Court authority that then looks at SC. So A and B.
Is A and B, is that the criminal injuries compensation law case? As reported, it's only called A, but
Oh, sorry.
none at all. Then I just was sort of puzzled.
There were two. It was A and B. So it's at 1-3.
The law reporters have a funny way of reporting cases. Yeah.
So it's at page 42. Sorry, tab 42. Page 132.
I'd forgotten that was the same day. Yes, I see. Let's put A and another.
Yes, that
Right.
another was called B.
You and Ed added this with me, Mr. Morete.
Yes, my lord. Justification is dealt with at begins at paragraph 80, which is 1357, and so paragraph 80, bottom of 1357. What requires to be justified?
So I've lost a completely new one. Which,
Sorry,
We've
paragraph.
left SC.
yes,
haven't
so I was half listening to A, but I was reading more of SC. So whilst I was asleep, you've gone to tab 46, have you?
42.
we? Two.
42. Oh, no. I'll wake up in a minute. Give me time. So yep, okay.
It wasn't honestly. It's a very well put together bundle, but if the people putting it together had been absolutely on the ball, they would have put it next to SC. It looks at it as much earlier.
It does. It's reported in the.
No, I can see exactly why they did it. I'm not. You don't have to have a PhD to them.
So paragraph 80, obviously what requires to be justified is a difference in treatment arising from the relevant legislation.
So where you read 82?
Well, sorry, 80 just sets out.
No, I just want to know what you're
82.
reading.
Sorry, I'm reading at paragraph 80.
80.
1357. What requires to be justified is a difference in treatment arising. Here we're dealing with difference in treatment arising from the provisions of the Employment Rights Act. So paragraph 82 is the part which then deals with SC. And the Supreme Court, this is Lord Lloyd Jones, who was in SC, refers to, at paragraph 82, the flexible approach when deciding what standard is to be applied. And then goes on to say, in the present case, the appellants have accepted correctly, in my view, that the applicable test here is whether the decision to adopt a measure under challenge was manifestly without reasonable foundation. A number of features of this case strongly support this conclusion. So, on the one hand, we just had the decision of SC that's been handed down and said you don't use a manifestly without reasonable foundation test, you apply a nuanced approach. And then immediately afterwards, the Supreme Court hands down a judgment that says, well, in this case, manifestly without reasonable foundation test is a right, entirely appropriate test, they say at paragraph 85. And that is for three reasons. At paragraph 83, we're dealing with the field of social welfare policy. A paragraph so dealing with question and whether, if so, to what extent the state should pay compensation to victims of violent crime, essentially a question of moral and political judgment, and then finite resources. 84 deals with the fact that the statutory instrument has been reviewed by Parliament.
This was an affirmative resolution case, was it?
So the case is stronger because it's not merely a statutory instrument, it is primary legislation. And then thirdly, the basis of the discriminatory treatment is also relevant. We're not dealing with suspect grounds here. Now, so say the one area that might be said different is that, well, we're not dealing with welfare benefits here, we're dealing with social policy. SC sets out.
I'm sorry, I'm keeping your hand in SC. Are we going back to it? You went left SC to go to A and B. Are you coming back to SC? No, I'm not saying
No,
you should.
I don't think I am, no.
Put it away.
No. The next one I'm going to is Spear and Stormshore.
Yeah.
Which is at tab 44. And the Steer and Stormshore is dealing obviously with whether Article 14 discrimination in the context of the difference in whistleblowing legislation as compared to discrimination legislation. And the Court of Appeal deals with justification from paragraph 55 onwards, correct to say. They'd already determined there was no relevant other status here, so this is obiter, but it's nonetheless important. And if one looks at paragraph 58, which is at page 1425, it's unnecessary to embark on the question whether the appellant would have to show that this policy was manifested without reasonable foundation. There's reference there to the Lawrence and Fenn Tigers case, which relates to costs in the civil jurisdiction, and where Lord Newberger and Lord Dyson say, even in the field of access to justice and legal costs, the court, while being vigilant to protecting fundamental rights, must give considerable weight to informed legislative choices, at least where state authorities are seeking to reconcile the competing interests of different groups. And Lord Justice Bean and the Court of Appeal go on to say we don't have to determine that because we don't have to determine the exact test because the rationale for where the Parliament has drawn the line is not hard to find at paragraph 60. And then at paragraph 62, the Court of Appeal expressly say it's not for this court to say whether placing additional burdens on employers, or as Mr. Milson would put it, conferring additional rights on employees who have been victims of discrimination is a good or bad thing. That is an assessment for Parliament to make. And that preceded post dated. Sorry, I'll just make sure that's right. It preceded SC by a couple of months, but it is entirely consistent with it. So that is the correct approach to apply, and no, I won't go in detail through the or at all through the courts, the way the court dealt with the fact that Parliament makes decisions and its parliamentary privilege and the way that Parliament works. One can't try to assess the way the logical rationale given by Parliament, partly because you're dealing with hundreds of people who may have one reason or another. But it's very clear in my submission that it's that high level of test that is required in order for the courts to ensure that there is the appropriate separation of powers. Now, of course, if this were a case where we're dealing with a suspect ground, the courts would want clear, apply a strict test, but this is far from that. Just the other point that was mentioned is, and the reliance as to why different tests should be referred to yesterday was that we're dealing with Article 10. In my submission, there's no reason in principle or logic why a different approach should be applied when we're dealing with Article 10 as compared with, for example, in SC, Article 1 of Protocol 1 or Article 8, because that's a family case. And sorry, I will return to SC. One can see there that we are dealing with family rights at paragraph 187, for example. Where, having gone through the review of the authority of the Supreme Court, paragraph 187 of 1591.
I've got lost now. Which authority are we on?
Sorry, just SC, paragraph
In
187.
fact, we've gone back to SC.
Sorry.
On what page?
Page 1591.
Right, yes, and where
So paragraph 187, it just shows that that case is an article, it's an article,
yeah, oh, I see. Yes, well,
and the test is whether the difference is justified.
No, we haven't got Bank Mellet in the bundle, so I assume that nobody's saying we should approach it. But occasionally I see references to the 4-tier test in Bank Mellet, and Mr. O'Bottom made claims that some of the legislation didn't have a rational connection or was not less intrusive than it needed to be. So what's your submission on Bank Mellet, apart from the fact it's not in the bundle and therefore nobody thinks it's relevant?
Yeah, well, the approach to take is the approach as set out in SC. It very clearly sets out the approach in Article 14 case. The question is whether applying wide margin of appreciation, paragraph 107, the question whether that difference in treatment is justified depends on whether it was used a legitimate aim, and if so, whether there's a reasonable.
well, we know what the test is in SC. The question is, what's the answer to my Lord's question? Is it different from? I mean, Bank Mellet was a discrimination case, wasn't it?
Yes.
Well, it's
It was an Article 14 case.
yeah. So the approach, SC is not saying don't apply Bank Mellet. It's still saying you are applying a proportionality test, but the test that is being applied is a very high level of proportionality.
But that's all perfectly consistent with Bank Mellet. That would all feed into what you did at stage 4 in Bank Mellet. I think what we're just getting at is there some special reason why, having gone to a great deal of trouble in Bank Mellet to set out a 4-step process, that is not expressly enjoined in SC? I mean, my private view is that Bank Mellet is unnecessarily elaborate, and don't quote me on that, and is no different from the effectively 2-stage step. One gets in other justification contexts. What's the legitimate aim? Is this a proportionate way of achieving it? And the intermediate steps 2 and 3 are all inherent in that anyway. But maybe that's wrong. So have you an explanation for why in one discrimination case the SC says with great the Supreme Court says with great elaboration, here's a 4-step test, and in another one it says here's a 2-stage test.
Well,
Maybe there isn't
No,
one, but we'd like to know.
Because it's very difficult when you're dealing with fine nuances of statute, where you're looking at Parliament's decision, to go through a 4-step process in which for every differentiation you are looking for a specific aim, and then looking at whether the measure meets that aim and whether it's proportionate to meet that aim. One has to take a step back and take an overall approach.
Well, take rationally connected, and Mr. Rowbottom thing. The NHS legislation isn't rationally connected with the sorts of things you've outlined, because it covers people who've never worked in the NHS and are coming there for the first time. And says, well, if that's the legislation, he says if that's the test, that legislation is not rationally connected, or it's not the least intrusive, and therefore we shouldn't in some way apply that legislation. So it is necessary to know whether it's bank merit or bust.
But then the answer to that is the fact that there are some other people that can change within the rule is answered by the legitimate aim of ensuring clarity and consistency, and people know and straightforwardness, so people know the rule, and as referred to in A and B, the need for broad lines. That is itself a legitimate aim.
But can I just pick up and answer you? What is your answer that Bank Mellat was a case about secondary legislation? I think it was about regulations, wasn't it? We haven't got it. I think so. Sanctions regulations. Or maybe it was about an actual government decision, a discretionary decision taken against a framework. Whereas this is about primary legislation. Is that why there's
That certainly is a reason. The difficulty here
would be a sensible route, but I just...
That's really, I mean, the difficulty here is different cases will take different approaches. One can go to Carson.
Well, I know different cases will take different, but our point is trying to give guidance for the future. It would be quite nice to know, have a rational basis for saying follow SC or apply Bank Mellat.
Well, the reason is you are dealing with legislation that has been determined by Parliament, and there is not a huge difference between the two tests.
Let me put a frightening scenario to you. Just assume we have a rush of blood to the head, and we take a narrow view and say that SC is concerned with welfare benefits, the payment of public money. We have a further rush of blood to the head and we say, this is not such a case. Therefore, we are not following SC. Now, of course, he will apply for permission to appeal to the Supreme Court, but in the interim, when I turn over to the judgment and I look at the next page and it identifies the alternative test, will it be Bank Mellat, and how then will Bank Mellat apply here? As basic as that is what we're asking, I think.
Well, the difficulty is any legislation or difference of treatment has numerous aims. So difference of treatments within a legislation have different aims. So for example, you have the aim of protecting workers with information, encouraging workers with information to come forward. Now, the legislation meets that aim because it encourages workers to do so. It doesn't apply so much to other people not in the workplace because they don't have confidential information. So there you have a legitimate aim of the difference of treatment being the need to encourage workers to come forward with information to their employers, but that need doesn't apply so much to other people who are outside the organisation. You also have other needs, the needs to protect employers' rights and employers' ability to engage people in a practical way. And again, the fact that it doesn't extend to applicants meets that need. You then have the need for, in the NHS, to ensure a collegiate whole approach in a particular sphere that, and to ensure in a particular sphere where there is people live or die if people don't make disclosures, to give those people extra protection. You then have an extra need to raise concerns. You then have the need to ensure that rules are clear and consistent and can be applied. And that's why you then have these slight vagaries to say, well, someone outside the NHS, the applicant applies. So in any piece of legislation, in an Article 14 case like this, you have all sorts of numerous different competing aims, different interests at stake, and it becomes very difficult to go through a bank MELAT approach in respect of every single individual difference of treatment or reason behind it. And that's why overall, a much more sensible and proportionate approach, an approach that the Supreme Court has taken in SC, is to apply straightforward test is the difference of treatment without objective justification. So of course that includes looking for the legitimate aim, but when you then have to try and look in detail for rationally connected to the aim, it becomes much more difficult.
So when we've decided that this is not a suspect ground, and if we accept your submissions that this is legislation and you've got to give it great respect, and it was actually recently reviewed, and we say, yes, those are all factors that go into the nuanced approach, and they favour your submissions, we still have to do something, don't we? Because even if all of that is true, we might still say, but this is not justifiable for the purposes of Article 14. So what's the extra bit I do?
Well, the extra bit you do is what's set out in my submissions under from paragraph 66 onwards. And the important thing about
Paragraph
this
which?
66 onwards.
Of your written submissions.
Yeah.
Oh,
I think the important thing about this is that it
Well, wait, let's just see them. All right. Yeah, sorry, you were about to say the important thing is.
you can't encapsulate objective justification in one sentence, in one phrase, because as I say, there are numerous differences of treatment. So we start, what is the purpose of legislation? It seeks to protect the public by giving workers who are aware of wrongdoing in the workplace and raise them internally and responsibly a remedy should their employer object.
Sorry, are you now? I may have misinterpreted my Lord's question. I think he was asking you to make your submissions. I think he was just wanting to understand the nature of the task.
yes, what do I do next? I've decided I've ticked 3 boxes in your favour. Do I say, is this a fair balance? And I say to myself, no, it's not right. Why should people suffer who are job applicants? They're just as useful as everybody else. Or don't I do that? I mean, what am I supposed to do, having ticked your 3 boxes,
No,
assuming I tick them in your favour?
you don't say, is there a fair balance? You say, is the decision made by Parliament one which is, in essence, one which is irrational? The distinction made by Parliament in terms of excluding applicants, is it irrational? Is there no objective reason for it? Yeah. And we say there clearly is an objective reason for it. And that reason is because it seeks to protect workers and people.
Okay, well, we know what you say the reason is.
That's
What about proportionality? That's got to come in somewhere. I've got to weigh, haven't I, the fact that assuming we accept what you say that there's a legitimate justifiable reason, don't I have to weigh that? I mean, if they said, for example, well, I won't give further examples, they only confuse things. The real question is, having found all for you, assuming that we do it all down the line, what do we do next? We have to look at proportionality.
My understanding, just to give you time to think and to confuse everybody, is that on your submission, in this kind of case, there is no further role for proportionality. Or you could say proportionality is answered by saying that the legislature has made a a rational decision on that. And that's that, whether or not you call that proportionality, or you say that means you don't need to look at proportionality, is a matter of semantics. But you don't have a separate test of proportionality thereafter in a case where primary legislation is applied. That's what I think you're saying, isn't it? Whether it's right is another matter.
But is that what
Let's see, for
SC
example,
says you
Lord
should do?
Reed, paragraph 208 at the very end of the so, I mean, paragraph 193, for example, the Supreme Court do address questions of is there a rational connection between the objectives of the legislation and Parliament's decision. So we are still looking at things such as is there a rational connection. But you've got to do it in the light of the very wide ambit that is given, and in light of the fact that there are numerous.
I know that, and I've done that.
You've helpfully referred us to 208.
And then 208, exactly. The assessment of proportionality, therefore, where it talks at the line before, bottom of 207, Parliament must have considered that the impact of the limitation on the interests of children would be affected by it was outweighed by.
So where are you reading from?
The last sentence of paragraph 207.
Oh, right.
Where the conclusion of that paragraph is that Parliament must have considered the impact of limitation upon the interests of the children who would be affected by it was outweighed by the reason for introducing it. The assessment of proportionality therefore ultimately resolves into the question of whether the Parliament made the
Yeah,
right.
that sentence taken by itself will be capable of misleading. So it doesn't mean that the court must decide whether Parliament made the right judgment. It means the opposite. It means, as we read on,
It cannot be answered by any process of legal reasoning. There are no legal standards by which a court can decide whether the balance should be struck between the interests of children and their parents receiving support. The answer to such a question can only be determined in a parliamentary democracy through a political process which can take account of the values and views of all sections of society. Democratically elected institutions are in a far better position than the courts to reflect a collective sense of what is fair and affordable, or of where the balance of fairness lies.
that is essentially the proposition I attributed to you, isn't it?
Yeah. So I mean that's what you're doing. You're reviewing. Is it irrational? You do. It is a proportionality test of sorts. But if you take the view that taking into account the aims and purposes at stake and the different interests at stake, it is rational. Parliament has made a rational decision. There is no basis on which the court can properly intervene.
But is that to be read as laying down an irrationality test for any piece of primary legislation, or is it dependent upon the content?
It will.
I mean,
It
that
will
was-
provide. It'll depend on the particular.
Yes, it will.
But as I say here, the point is here we are, when you are dealing with a suspect ground, a ground that is, say, a long way away from a suspect ground, the purpose of legislation is to make differentiation. And the purpose of Parliament is to decide where that differentiation is. Where you are having to rely on a status which is far from the original provisions of provisions set out in Article 14, then one has to take a step back and say it is for Parliament to make these decisions. So unless that decision is irrational, if it is irrational, if there is no legitimate aim, or it cannot rationally be connected to the aims of the legislation or the reason for the different treatment, then that's when you can step in, but otherwise you can't.
It's funny because I've gone back to A again at tab 42, and Lord Lloyd Jones goes through all the matters at 89 that you mentioned. Is it a suspect ground? Is it legislation? And then his last paragraph, 92, applies the bank merit test. I consider the difference of treatment is justified, legitimate objective, satisfies the requirement of proportionality, rationally connected to the objective, no more intrusive than it requires to be, and strikes a fair balance. And he seems to be saying he thinks that that's a fair balance, not that because he's answered the questions in favour of Parliament that you've put, that therefore it is that. Or is he saying that? It just seems very odd. There's this inexplicable, we have two tests, we're told there are lots of factors for a nuanced approach, and we're left hanging in the air if we find the factors favouring a very nuanced approach, of the sort you like, exist. Say we thought it was just totally unfair. Really harsh on people.
If you thought a measure was totally unfair, totally irrational, totally arbitrary, then, I mean, depending on the ground, there might be a reason to intervene. But as I say, the problem here is we are dealing with something that is a long way away from the suspect ground. So it would have to be very clearly irrational in order to intervene.
All applicants for jobs can get it unless they're applying for jobs as an estate agent. Because that's not seen as a socially valuable goal by Parliament. Now, other people might say, well, hold on a moment, they're doing a day's work like anyone else. Why can't they get the same protection?
I mean, a better example is Gillam, isn't it? I mean,
Or Gillam,
why shouldn't judges have the same rights as everyone else? Just
Yeah.
because they don't constitutionally they don't have contracts.
That was the problem, that no,
Okay.
the why question couldn't be answered. But if the short point is, well, why should there be a difference? And if you can't say why is there a difference, then
So if Parliament reviewed it and said, well, we thought about it now, and they're office holders, not workers, and we still don't want judges to have it, that would automatically be the end of it.
If you would approach it with further respect because it's being reviewed again by Parliament. But if a court decided it was still irrational, I mean it's a hypothetical question because
Well, it's not irrational, arguably, but it might not strike a fair balance because if there's another stage.
but then it's the court isn't asking itself, does it strike fair? The court is asking, is it irrational of Parliament to decide it strikes a fair balance? Essentially, that's the test.
Yeah. Well, there we are.
Just on the subject, I noticed that 174 of SC, Lord Reid said the legislation must also satisfy proportionality test.
Yes, that is giving it.
My Lord's question.
Yes,
from
that, I say, that is giving
But
it.
the oddity is 208, which seems to say, if read one way, it says we must answer the proportionality test, but it is automatically answered, at any rate in the case of legislation of this character, by Parliament having decided what it wants to do, how it wants to strike the balance. That's the end of the matter, because it's Parliament.
Yeah, and well, that is a very, very strong
Yeah.
indication, and I can't say what possible.
Well, that's
situation
why
there
it
might
must
not
be
be, but-
sensitive to context.
Yes.
But also, presumably, this discussion needs to be read in the light of what Lord Reid has said at some length. It's very helpful about the difficulties of looking at these issues when you're looking at parliamentary primary legislation, see 165 and so on.
Yeah, and
Following text.
and the key.
Under 208, of course, he's dealing with particular legislation. Yeah, he's
Yes,
gone back
yes.
to applying it to the particular
Yes.
legislation. And this is about, should we give, I forget if it's tax credits or benefits, but it's all about that. And that's different. Say if you're in the criminal justice sphere and you've got a rule that says over 18-year-olds don't get something and under 18-year-olds do get something, you might think, well, hold on a moment, you know, or over 18-year-olds get triple the sentence of 17-year-olds. There, you might think, well, hold on a moment, there's not so much call for restraint there.
My submission, the answer is at 162, where the Supreme Court sets out, it is also important to bear in mind, almost any legislation is capable of challenge. And so,
Yes, I think you hadn't further. So is that the one where he cites with approval the dissenting opinions in JD,
yes,
which are powerful. But,
1583.
yes, that is 162. Yes.
And
Yeah.
and that describes the issue here is that like, the art of legislation is to differentiate.
Yeah.
Differentiates between identifying certain classes of person. Any legislation may be contested from the viewpoint of principles of equality and non-discrimination. and such
Well, we
cases come
read
more
it,
common.
yes.
And that's why the court, I say, have to step back where we are dealing with social matters, where we are dealing with interests of different people, of different parts of society, and where we're dealing with a non-suspect ground, a distinction from within the legislation. And because otherwise we have a court making a decision based on submissions and the limited evidence before them. You don't have, for
Yeah,
example.
well, we understand the point, yeah. Right, now, I mean, you virtually, we have asked you some questions and we were indulgent to Ms. Darwin, so we'll be indulgent to you, but how much longer, how many other points have you got to deal with? Have you magically
I
dealt with all
will.
your
I'll
points?
be very brief. I can deal with the NHS point,
Oh, yes.
And remedy?
and I haven't dealt with other status. I'll deal with that very briefly.
Yeah, okay, well, to deal with your remaining points, we'll,
NHS. If one goes to section 49B of the Act, which is tab 1, page page 36. The first point to note is this applies to an NHS employer, so it doesn't apply to the private care sector. Only doesn't apply to private employers. The second point, section 49B1, is a completely different form to discrimination, to more other provisions of the Whistleblowing Act. The issue,
what, different in what respects?
In
I see the
respect-
wording is different,
Yes.
but it isn't, in most respects, it comes to the same thing, doesn't it?
well,
What's the substantive
the
difference?
substantive difference is a reference to it appears. So from discriminating against an applicant because it appears to the NHS employer that they've made protected disclosure. And that, in my submission, demonstrates the difficulty that I was talking about this morning, which is the main provision, section 43B and 47 deal with discrimination on the ground, i.e. the employer can know that someone has made a protected disclosure, be able to assess that, whereas here we're dealing with perception, appearance. So it's a very different.
What's the reason for that?
Well, because as I say earlier, an employer can't know, because you can't know the detail. It's merely it appears to you rather than actually because they have made protected disclosure. Now, what's happened here is that Parliament has said, despite the difficulties that may apply to a private employer faced with a potential claim from or an applicant being able to bring a claim, we can cope with it in the NHS. And we can cope with it in the NHS because A, we have been told that urgent action in this sector is required by by the report by Sir Robert Francis. B, this is in essence a monopoly employer. It's akin to a monopoly employer, so that it can be difficult to find a job outside of the NHS if you're in this particular work. Third, it's a state employer. Okay, we're only dealing with the state, the NHS. Fourth, we're dealing with critical matters of patient safety, where there is a risk of many people dying if people don't raise concerns. And five, there is a need for a culture of transparency within the NHS to deal with that, the NHS being an area in which the government's health secretary has responsibility. And the short point, and I'll come to bits of the Francis review, we've looked at it in some detail, but it cannot be the case that where Parliament decides and has been told and therefore decides to take urgent action in respect of a sector, that it should apply the same approach to everyone else or other sectors.
Or
Go and
Hold on.
look and see the extent to which,
This is my lord's point before lunch.
yeah, because otherwise you will not have a reaction. The Parliament will be prevented from addressing urgent matters like this and taking sector-specific approaches in areas for which they're responsible. Because, I mean, in short, the upshot could well have been no action is taken about the NHS because
Yeah, we got
it
the
also
point.
applies to supply. So, I mean, just references in the Robert Francis review, one looks at paragraph the supplemental bundle, page 113. So we start at 111. Page 111, the letter from the introduction is a letter to the Secretary of State for Health. Again, it refers in the first paragraph to design to making the culture of the NHS patient-focused, open and transparent. About the culture of the NHS as a whole.
Well, rather than just reading bits out, especially as time is short, how much of this do you want us to read?
Well, the first two paragraphs.
Okay. Yeah.
The bottom paragraph over onto 112,
Sorry, bottom paragraph.
of 111 onto 112.
Thank you.
Yeah.
The last two paragraphs at page 113. So where it begins, there is a need for a culture in which concerns raised by staff are taken seriously.
Sorry,
Two
113,
paragraphs.
which paragraphs? The last two paragraphs.
Yes, not the last sentence, but the last two main paragraphs.
Yeah.
1124 at paragraph 64 talks about.
1124, did you say?
Sorry, 124 paragraph
124.
64.
Which paragraph?
Paragraph 64.
Yeah.
128. Paragraph 93.
Yeah.
And then 129 paragraph 95 and 101.
Yeah.
And then 176 paragraph 9.11. 9.13.
913, as we might call it.
Yes. And then 177 at 9.17. And in particular, firstly, I do not think legislative change can be implemented quickly enough to make a difference to those working in the NHS today. What is needed is a change in the culture, the mindset of the NHS, so that concerns are welcomed and handled correctly. And that's
What about the point that that's all very well if this was coupled with a commitment to look at the remainder of the Act, albeit at a slower pace.
well, two things. As a matter of practice, the legislation allowing this was primary legislation was done very quickly. Following the consultation, this came into force in May 2018, which is not long before the act in this case. So if you're saying, well, a bit more time was required, then for evidence gathering. But I mean, if the complaint here is that the previous government didn't gather evidence, then that's a different matter.
Well, I think that is that. I'm not saying it's a good point or a bad point, but that is part of the point made against you.
Well, Parliament can only legislate on the basis of evidence. We can see the clear reasons in Parliament. They have evidence in this sector. They don't have evidence.
You can't shuffle it off entirely onto Parliament. It's a legislation is a two-way. It's a partnership. Parliament, the government has to propose legislation, and Parliament then has to pass it.
But I mean, you have some evidence before you, but it's limited evidence. That you have a witness statement from Protect, who refer to a number of case studies and say there's a general problem in a number of areas. But if you have to assess whether there is the decision made by Parliament is irrational, and unless there is before you that extensive evidence of extensive problems, then it's very difficult for you to say that. In any event, it's for Parliament. In the end.
Yep.
Just briefly on other status.
Yes.
There is a point here on other status, and the court can't simply go for its justification. The test, and no one's referred to this so far, but the approach is most clearly set out in Stott at tab 40. That's tab 40, page 1254, paragraph 56.
Which paragraph?
Sorry, paragraph 56. Now, what Lady Black does is looks at the position and the factors you take into account pre-Clift. So post-Clift in the Supreme Court, pre-Clift in the European Court of Justice, and then returns to them at paragraph 63 to say which matters still apply.
Yes.
And then if you go to paragraph 63, it then reviews those. You have to cross-reference the two.
So 1, 2, and 3 are ticked.
Yeah. Four lives on in Doherty and still lives on in, for example,
So what lives on?
the proposition that there has to be the personal characteristic can't be defined by the differential treatment that is of which the person complains.
Yeah.
Um,
Then
That's
5.
5 is I mean, what Lady Hale says is the search for analogy is
Lady
becoming
Black.
more and more. Sorry, Lady Black said the search for analogy is becoming more and more difficult. However, that should not have
Yes,
caused
I see.
undermined
So
system-
5 is watered down, perhaps. Or,
system.
but
And then 6 should not be pursued abstract. Whether it assists will depend on the facts of a particular case.
yes, I see. Okay. So basically, 5, 6, and 7 are rather blown on.
7 is about justification. So
Yeah.
7 goes because that's justification. 5 and 6 are watered down, but they are still
Okay.
help. Now,
Thank you.
the short point is that so those still do help. And although other status is given a wide meaning, it is not redundant and should not be treated as redundant. That, for example, is referred to, I'll just give you the reference, Lady Justice Simler, paragraph 28 of Dudley and Maley from last year. That's at page 1883, which is tab 53.
Tab what, sorry?
53.
Just a second.
It really does only just say that point.
Well, okay, but can I just see it all the same? Which paragraph?
Paragraph 28.
It's okay, thank you.
There are numerous situations where people are doing things or have done things that does not give them status. So, for example,
Oh, sorry. Just turned over the page in Dudley, and the case I had in mind, what I referred to this morning about section 3, is called Ivanchuk, and I see that it's actually cited over the page.
That's actually in the Supreme Court, I think.
Yeah, well, that's what I was saying.
Yeah.
It's in the Supreme Court any minute now. Anyway, there we are. Sorry, that.
so
So the examples of cases where somebody has done something to them.
does something.
Yeah.
For example, hunting, being a fox hunter, is not another status, and that's Countryside Alliance, tab 17. Lord Bingham, paragraph 24. So that's page 365 of the Authorities Bundle, with whom the rest of the Supreme Court agree. Lord Hope, paragraph 89. Lady Hale at paragraph 130. The Clift, at least in the domestically, was not another status, where the difference there was someone serving a 15-year print sentence as compared to someone serving a longer sentence. Being a terrorist, so for example, Gurga.
Well, don't run on with the examples as you're running out of time.
Okay.
But
The one other point then is steer, which is important, which is that being a litigant is not a status.
Yeah.
Paragraph tab 44.
examples are all in your stone,
Yes,
aren't they?
yes. So it's tab 44, paragraph 36, which also refers to Hooper in the Supreme Court, which makes it clear that being a person who has started legal proceedings does not give rise to another status. And therefore, I mean, we simply say that being an applicant for a job, doing something, applying for a job, is not sufficient to give you another status. Very briefly on our role, I've set this out at the end
On
of
our what, sorry?
the role, and you, my lord, raised questions yesterday about these issues being raised in the Employment Tribunal, Court of Appeal.
Oh, yes.
These types of challenges are becoming more frequent.
Yes.
There is Steer and Stormshaw, which was dealt with through submissions in the Court of Appeal. There is Gillam. Gillam was raised by Protect, the Article 14 argument, just before the Court of Appeal hearing. And the MOJ objected
That's right,
at the
we
time.
allowed it in.
So, and that was dealt with by submission. What we did in this case was obviously presented the evidence, presented the parliamentary material. That is essentially set out in the supplemental bundle.
Yes.
And that's
So what this boils down to is there is at least a little bit of a practice simply of the government coming in when a case is clearly a leading case, which it probably won't be till it gets to this court. You can see it's a matter of your choice whether you try and get in EAT.
Yeah,
And you had the chance in this case, which you turned down.
in this case.
Yes. This case, what? Well, no, I'm sorry. There was evidence that the government legal department, Treasury solicitor, well, that's technically the government legal department, was written to,
Right. Okay.
saying, "Do you want to join in?" I haven't misremembered that, have I?
It's from steer,
sure
that's
that's
what happened
right?
in steer.
Yes, but it's referred to somewhere. But anyway, it doesn't matter. But I don't want to spend too much time on this, but you're quite right. I did raise it yesterday because I was concerned about if every employment tribunal has to deal with questions of justification without the benefit of the government being there, it's an unsatisfactory situation. But maybe that nothing very much can be done about it.
Well, as it is, McLennan is going back to the Employment Tribunal to determine whether a charity trustee has other status, and
But it's going back on the. But how did that come about? Well, is that because the point was only the justification was only introduced at the EAT stage?
the tribunal didn't determine justification. The tribunal, the EAT said erred in dealing with status and analogous situation, and then didn't determine justification.
Oh, I see. But then McLennan's a bit of a red herring, isn't it? We're talking about cases where justification has to be decided by the Employment Tribunal, but without the benefit of representations from the government.
Yeah, well, that would have with what happened in the first instance. The government weren't there. It's now going back, and the government will be there.
Yes, I see.
There's another case, Oni, which is dealing with foster carers' rights, and there are numerous Article 14 arguments raised there. And in that situation, again, the Secretary of State attended. It's
in the employment in the first tier tribunal,
yeah. And there was cross-examination of a civil servant. Now,
yeah,
I mean, in terms of how do the tribunals deal with this going forward? Now, our primary submission is that the test is a high one, and therefore there should not be many cases in which the Secretary of State needs to provide submissions. But if the argument is raised, it seems to me that the Employment Tribunal should invite submissions from the Secretary of State rather than there being evidence or cross-examination.
I'm not saying we'll do this, but is it your instructions that you would like us to say something in our judgment to say that rather than these points having to be dealt with for the first time appellatively, employment tribunals should be aware of their right to and encouraged in appropriate cases to invite the Secretary of State, the appropriate Secretary of State, to make submissions, whether in writing or with evidence, depending on.
Yeah, I mean that's what we've set out in the skeleton. Yeah, and
I'm sorry, I missed that. Is there a passage in the skeleton dealing with this? How about
sorry, paragraph 80.
I must have read it. That's probably why I was interested in the point in the first place, but I'd forgotten it was you, not me, thinking of it. Paragraph 80.
Yeah.
You see, it's covered in the High Court above because there's a declaration of incompatibility, and Part 19 says we've got to let the government know.
Yeah.
But it's also Section 3, even if it's not incompatibility, and that's the problem. And you wouldn't be evidence, but you wouldn't necessarily expect a small employer, 1-2 people, to have access, for example, to the Lord Willis debate and the Francis report in this case. They've got to run a business.
Yes, yeah, absolutely.
Realistically, you said a criminal aspiration if you're the claimant to invite submissions. I think it's implicit in what the Lord said. The justification, the onus will be on the respondent, so they'll be the. But it's unrealistic, frankly, to think that parties, in many cases where this may come up, will be in a position to assist. So you are I now see this. I'm not surprised I overlooked it. It's only a single sentence, but it is your position that in any case where a question of justification of legislation, does not have to be legislation, otherwise the private employer would be bound by it, is being challenged under Article 14, possibly some other legislation, some other article, to be invited to make submissions. You may find yourself, I won't say deluged, but
Well,
this
exactly,
may
that's
become an
difficult.
increasingly common
Well,
practice.
it is becoming increasingly common,
Yeah.
primarily because of
So it would be helpful if we said something to that effect, you think?
yes.
Yes, I see. Thank you.
I say we hope it won't be.
No, we know,
the
and
test.
it may,
Um,
right, thank you, that's helpful.
just very briefly on the sorry.
Wait till
Sorry,
you
forgive me.
reply, or do you need to deal with it now?
No, I thought my letter finished.
Yes,
I
I
just
was
want
talking as if you were talking about remedy, but of course, remedy fell into Mr. McCombie's.
Can I just make one thing clear there?
Yes.
In terms of declaration of incompatibility.
Yes,
I've set out at paragraph 84 that the government set out its plans for workers' rights in detail in any event more appropriate for such matters to be considered. For
can you
Parliament.
speak up a bit?
Sorry, sorry. It'd be more appropriate for such matters to be considered by Parliament as a whole rather than any specific amendment made in accordance with Section 10 of the Human Rights Act. Just to be clear, obviously, when this was written back in September, the new government was very newly in place. There is no current plan to review the whistleblowing legislation, except for the very limited provision within the Employment Rights Bill that you will see at S335, which is. So I'm not saying that you shouldn't make a declaration of incompatibility because.
Yeah.
Because,
Well, but the default position is we should, if we get to this point, make a declaration of incompatibility. And is this the position that you are not suggesting there are exceptional circumstances here why we shouldn't?
no, I'm not saying.
Fine. Thank you. I'm sorry we've rather rushed you at the end, but you're in the same boat as Mr. Darwin, who's equally rushed. Yes, Mr. Chubb.
I've got several subsidiary clarification points arising,
Yes.
and one slightly more developed point which I'd like to address the court. So just dealing with a few points that have arisen. My Lord's note, the reference to the DLD being contacted by EAT is paragraph 99 of the EAT's judgment.
Yes, thank you. That's fine. I remember it, but yeah.
Just so my Lord's aware that having lost in the EAT, the claimant herself appealed to this court. Lord Justice Singh granted her permission, and Lord Justice Bean then asked that pro bono counsel, i.e. me, would step back in, which I gratefully, my letter from Mr. Oakbottom
We're grateful
came in.
for you.
Okay, well, I'm not
get
making
by
that
you.
point, but then what happened was at that point, we suggested the notification of the DLD again, and that's why they've come. That's why
Sorry, at that point,
Lord Justice
Lord
Justice
Justice Bean said.
Yes, I think it might have been. I can't recall whether it might have been my instigation
Might be
that they should have.
Yes, I think, well, somebody deserves the credit for it.
So that's that point. Just in terms of the SC Bank Mellet debate, our position is this. Bank Mellet remains good law. We can see that from paragraph 92 of the AB CICA case.
Yeah.
What SC does is it reminds the court in fairly clear terms that when you're dealing with primary legislation, then it has to take a much more nuanced approach and really has to, in a sense, step back much more than
It's
you
a
would
gloss
do.
on step 4,
It's a
or a
gloss.
guide to how to do step 4. Is that right?
Precisely, but significantly, it doesn't obviate the need for things like rational connection
No.
and so on and so forth. And when I come to
It's all right, it's not in the bundle then, it sounds jolly
Well,
important.
well,
You think we know it?
you might, well, firstly, not only do you think you know, it might be slightly odd in a bundle which has got however many authorities we've got. We did have an attempt to weed out the authorities,
Yes,
and as
no.
there was no dispute about the principles in Bank Mellet, I
Very
think that may
proper.
have come out.
Nobody is being criticised. But just one more point about that. The structure of SC, although it looks like the absolutely comprehensive guide, it's not actually that. The way he sets it up is he says, here are the well-established principles, which are very shortly stated, and there are 3 particular points I want to deal with in detail.
Yes.
So he's not and one of them is what to do about proportionality in the contents of primary legislation, as well Humphreys
And also,
manifesto and all that.
yes, and also the role of parliamentary material and so on. which is quite
Exactly, and then I've covered with the other one. Oh, there's one about direct and indirect discrimination. But the point is, it's not actually intended to be the last word. It's intended to be the last word only on those particular points. Yep.
Yeah, well, that's exactly the way we put it.
Yeah.
The one point I want to just develop it with a little bit of detail is this, and it goes back to the purpose, stroke legitimate aim of the legislation. There are essentially three aims that have been ventilated here. The first is the aim set out in Millennium Friend's skeleton argument of paragraph 73. Provide protection for the public by giving workers who are aware of the wrongdoing in the workplace and raise concerns internally, etc. I think even Millennium Friend accepts that doesn't capture the full ambit of the legislation. The next aim is, if I may respectfully say, is that ventilated by the court, which is perhaps most particularly articulated yesterday by Lord Justice Lewis, which is in a sense that the aim is, and this has regard to the specific wording of the statute, is to provide protection to those persons who have a contract of employment, a workers' contract, or something akin to that, and or are NHS job applicants against retaliatory action by their employer or would-be employer. The third aim, which we advanced in Mr. Robot in our skeleton argument, comes directly from the preamble to the Public Interest Disclosure Act and the 2015 Act. And that is, and it's stated, I'll give you the reference, I don't need to take it up, it's page 54 of the Authorities Bundle for the 1998 Act and page 65 for the 2015 Act. An act to protect individuals who make certain disclosures of information in the public interest to allow such individuals to bring action in respect of victimisation and for connected purposes. Now, what we say is the correct way of looking at it is to take that broad aim, and this picks up a point that my Lord Justice Underhill mentioned yesterday, is that Parliament took the view that the best way of protecting people was through Part 4A of the Employment Rights Act, because in the main, most people are going to suffer detriments in the employment field. And the way of recognising the public interest and necessary public protection set out in the preamble to the 98 Act, and includes in the title, the Public Interest Disclosure Act, is through that mechanism. But looking at the wording of Part 4A doesn't give you the whole legitimate aim or purpose of the Act. And we know that's not the correct approach because that's what Lord Bingham told us in Countryside Alliance, because in Countryside Alliance, the aim of the hunting legislation in that case was very broad. And the appellant huntsman, said, well, hang on, none of that's in the Act. And we see that from paragraph 40 of Countryside Alliance, approved in SC at paragraph 172. So you don't simply look at the wording of the Act, but you look at the whole overriding purpose. And the overriding purpose is to recognise that whistleblowing has a significant public interest. And that public interest doesn't start and begin with the employment relationship. The reason the employment relationship has been the method of capturing it is because it's in a sense, a ready-made vehicle already on the statute book, rather than having to set up an independent regulator for whistleblowing. But if we look at it that way, and we recognise that Parliament has used the employment field as the mechanism for protection, we can see that the rationale for excluding job applicants becomes much weaker.
What happens in 2015 when they actually decide whether or not to include applicants and they say, no, we're not, by a vote of 314 to 217?
The difficulty then, we say, comes with what, and I'm not going to try to repeat Mr. Rowbottom's submissions from yesterday, but it's obvious that the court is aware of that submission, because if you're going to carve out or recognise a particular group, the NHS job applicant, but you then draft legislation which doesn't apparently recognise the sole purpose of that, which is the protection of patient safety, but drafts a whole scheme which captures any job applicant in the NHS, then you're in, we say, territory where you are in a essentially irrationality territory, because you're moving away from what is the apparent purpose and expanding that to any job applicant in the NHS. Now, just on that point, it's important to have regard to two other points. The first is that one of the jobs that the claimant applied for in this case was a finance role in adult social care. Now, that is very similar, one might think in conceptual terms, to a finance role in a mental health trust. In other words, they have a similar relationship to patient care, patient safety, or whatever. And it's very difficult to see the justification for distinguishing between the two. And the second issue, which comes back to the public interest point, it's right to say we're not dealing with a suspect class here, but we are dealing with an extremely important public interest consideration, that is the protection of people's Article 10 rights in the context of whistleblowing, which is generally regarded as being something of significant public interest. And one of the difficulties of excluding job applicants, and this has been from the protect evidence, is that people don't blow the whistle in their existing employment, not just because they'll suffer a detriment in their existing employment, but because they fear not getting a job in any future employment. And that is a significant matter of public concern and interest. And it also demonstrates why, if one takes a narrow employment protection focus, one loses a significant part of the composite purpose of the Act, which is this public protection of whistleblowers and making sure that people operate in a transparent way. And I'm not going to meet Mr. The department's points about good employers, bad employers, good whistleblowers, bad whistleblowers. We can all trade examples of that. It doesn't get us anywhere. But standing back and looking at the rationality of this, once you bring in such a wide protection for any NHS job, then it does rather beg the question, how do job applicants in financial institutions, in local authorities who deal with sensitive matters, in areas of policing and so on, which are collectively or groups of employers, police forces across the country, very similar in constitution to the NHS in terms of many employers, and word gets around. There were plenty of examples of industries like that. I don't need to labour the point that the Protect has dealt with it, but those considerations come back to the point I made right at the outset of this part of the submission, that unless you focus on and get the purpose of the legislation right, you're not able then to follow through the rest of it. It's only when we submit, think of the legislation in broader terms than merely employment protection, merely related to the contractual position of individuals, that you can see that picture emerging. That's the additional submission I wanted to make on that point. There are a couple of other points. Sorry, finishing off that point, we have set out in our supplemental skeleton an additional bundle. I'm not going to take my lords to it, but the less intrusive point, the fair balance point, which flow from that analysis of the purpose of the legislation. Just several other subsidiary points, just really for note. My Lord Justice Holgate drew attention to my submissions in the EAT in relation to the protected disclosure advance there. I just really, for the court's note, just draw attention to paragraph 12, page 13, where I identified 3 protected disclosures, the third protected disclosure being the one on the 17th of March. The 2, I think, that Lord Justice Holgate was referring to PDs 1 and 2, which were earlier but not relied on. And I also invite the court, whilst doing that, just to contrast the way the respondent put its case in the Employment Appeal Tribunal, which is paragraph 6, page 27 of the supplemental bundle, where the tip lady issue was not based on the argument run in this court, but was based on the timing of the detriment and the timing of the protected disclosure, rather than the fact of any link to the employment relationship. The next subsidiary point, again, it's a small point, but in relation to the appeal which is ongoing in the EAT against the victimisation point, at page 205 of the additional documents, the claimant, appellant there, is seeking for the victimisation claim to be set aside and remitted to the tribunal. So that may still be a live issue. I know my learned friend has views about that, but
well, the position may not be irreconcilable. The ground on which it's being asked to be set aside is not the one that is of potential interest. However, if it is set aside, to be set aside full stop, it'll go back to the Employment Tribunal, which will not be bound by its own previous decision. In practice, it will be, won't it? And it will be looked at again. Okay.
coming towards the end, the next issue is a submission my learned friend, the respondent, made on the meaning of 49B. We say that, with respect to him, just his submission in relation to that was simply wrong. It's quite clear from subsection 3 of 49B that if this claimant made a protected disclosure in relation to her treatment at interview, that would come well within the expression in 49B, page 36 of the authorities bundle, which is that she would have been treated less favourably than the council treats or would have treated other applicants in relation to the same contract, office or post. That the expression in relation to must encompass the interview application process. It's a wide enough term to do so.
That raises a slightly separate point. You've just reminded me, because you would submit that it also covers appeals against the way in which the process was conducted, and you've put in the employment, you put in the complaints policy, and it says this is all about the way services are delivered, and then it goes on to say we can do a number of things, one of which is reverse a decision.
Yes.
But in the context here, firstly, is it reversing the decision? Because I assume somebody else got the job. You're not trying to have that person's contract brought to an end and a new job thing going. And secondly, if you can't reverse the decision, and it was about the interview, does it matter? I mean, the councillor may decide to do other things, even if it can't reverse this decision, to try and make sure it doesn't happen again, in inverted commas, if that's the problem.
Yes, but I mean, there are two issues there. If the facts in this case had in fact been established, and the claimant established she makes a protected disclosure, what she said happened in the interview happened, the council carry out an investigation, discover that, and they say, oh, I'm sorry, but we've appointed somebody already, then they could take several remedial steps.
Yes.
They could say, for example, next time we have a post, we'll put you through the first stage without interview or whatever, or something. They could have taken steps to remedy
Well, they
that.
could have reimbursed her for the expenses of going to the interview. They could have given her an apology. They could have adopted practices to make sure that it didn't happen to somebody again. So I don't know that it's necessary for you to rely on the fact that his decision on the appeal process could have been reversed, when even if it couldn't have been reversed, if it were a connected employment thing, there might have been other things they could have done under the complaints policy.
Yes,
And you agree with that?
I'm grateful, my lord, and obviously I accept that. So, just to finish, and this is the last point I make, and just really to remind the court, we're not saying here that Parliament was not entitled to legislate for protection for whistleblowing latterly in NHS applicants' cases. Obviously, it was entitled to protect their Article 10 rights. What we say was impermissible, and we say irrational, if we need to use that test, was not to extend that protection to others when it was giving such a blanket protection unrelated to patient safety to every NHS job applicant, the NHS being the biggest employer in the country as we understand it. And it's not, finally, we say it's not realistic to say that every single NHS post is concerned with patient safety. No more than it is unrealistic to say that no local authority post is concerned, even if it's finance, concerned with patient safety. Once you don't make the link between patient safety and the measure adopted, then you open up an irrational connection between the two, and that's what we are essentially focusing on there. Those are my submissions, my lord. Unless I can give any further assistance.
Thank you very much.
I'm just reminded, I have, and I'll send it to the court in due course, the claimant's closing submissions in relation to you.
Thank you for remembering that. Most grateful. Well, we are most grateful to all counsel, both those who spoke, those who didn't, and indeed to those instructing them, for well prepared and cogent submissions. We will obviously have to reserve our decision. Judgments will be circulated in draft in the usual way for the limited purposes most recently and authoritatively identified in the Counsel General for Wales case, with which I'm sure you're all aware. But the key point is they should not be circulated to any person except those who need to see it for those purposes. For the avoidance of doubt, of course, clients can always see them. We've had a query about that recently. But if they are circulated to anyone who doesn't need to see them for those purposes, there's a potential for there being a contempt of court, so that needs to be taken seriously. Thank you all very much.
Court orders are